All right, good afternoon, everyone. I want to welcome you to our inaugural edition of In the Boardroom with attorney Andy Phillips and Attolles Law, brought to you by the Wisconsin Counties Association. So folks are still popping in, but we do have a hard stop today at 1 o'clock and a lot to talk about today. So at this time, I think I'm just going to turn it right on over to our speakers, Andy Phillips and Jake Curtis, who will talk to us a little bit about this new series In the Boardroom, and then walk us through our first topic, a county's role in regulating large solar projects. Andy.
Thank you. Thank you, sir. Good afternoon, everybody. Thank you to actually Sarah, you and WCA for hosting what is going to be a monthly series where we have discussions on issues of interest from the legal world and applicable to county governments. We came up with this title, In the Boardroom. Actually, Jake was the brainchild behind the title because he said, look, if it's going to be a discussion and a forum and opportunity to share ideas, thoughts, concerns, and questions, that's where we have our deliberations and our most important discussions in county government, and that's in the boardroom. So we thought that was an apt title, and that's why we named it In the Boardroom. We have, of course, regulation of solar projects on the docket for today, but if there are other topics in the future that you want to see discussed here, please feel free to let us know, and we'll try to get those topics on a future agenda. Couple of quick notes that if you have questions and want to discuss items throughout this presentation, there is a Q&A button at the top or bottom of your screen, or a chat button. Use either one of those buttons and we will get to your questions or comments as we go. Anything you wanted to add, Jake?
We'll definitely try to leave time for questions at the end. Obviously, there's a lot of interest in this subject, just awesome participation. So we'll definitely try to leave time at the end so we can answer any specific questions you have or address concerns or thoughts. Definitely want to leave time.
All right, so without further ado, when we talk about the concept of regulation of solar activities, I'm going to start and give a broad overview, and then Jake's going to do a deeper dive into this whole issue of regulating solar facilities. The reason Jake has particular expertise in this area is given his extensive work with a couple of counties that have had, I don't want to say a surprise, but all of a sudden we have these large solar facilities that want to site within a county, and some counties are better suited for solar facilities than others, and those that are particularly well suited for solar facilities might be encountering right now that same type of surprise, if you will, about the siting of these large solar facilities and so on. And so we've seen it be a big issue in terms of public involvement, in terms of landowner involvement, in terms of solar farm developer involvement. In other words, there are a lot of people who have a high level of interest in this particular topic. So we thought it was a great topic to talk about just broadly for all Wisconsin counties. So I want to tell you that the regulation of solar facilities is peculiar in that we have a statute where we deal with regulatory authority. But just at the outset, I want to kind of just provide the landscape here, if you will. And that is that we see these land use issues crop up from time to time, usually every couple of years. We started with cell towers and mobile communication towers in the mid-90s. We went on to large livestock siting. We went on to windmill siting. We went on to frac sand mine. We went on to metallic mines with additional statutory authority that came out about 10 years ago or thereabouts. And so we see these land use issues crop up from time to time. And we want to start with a basic foundation of what is a county's role in regulating the use of private property owners' land. So we're going to start with that. Then we're going to dive into the actual peculiarities associated with renewable energy facilities. And I want to emphasize that point is that it's renewable energy facilities, both solar and wind. And so we're going to dive into the regulatory authority there and give you some background. This might be rudimentary at points for some of you, and it also might be a little bit beyond just rudimentary for some of you at other points. Point being is that we wanted to give you an entire body of discussion as it related to these points so that you have in front of you essentially the entire framework for a county's regulation of solar facilities. So let's start with just this very general broad proposition. What do counties, just as an entity, have the authority to regulate when it comes to land use issues. And this is very basic. If you look at 5903 sub 1 administrative home rule, we have the power to exercise as counties any administrative power subject to any act of the legislature which is of statewide concern and uniformly affects every county. And so we know that we have the ability to regulate our local affairs unless the state legislature has stepped in and taken away that authority. And so the question often comes up, well, does a state law, does a regulation, does it actually apply uniformly throughout the state? And does it preempt a county from regulating in a particular area? And there are a series of cases, and the Lake Beulah case is the primary case dealing with this whole concept of preemption, deals with preemption not only from the county standpoint, but also the municipal standpoint. And there's a 4-part test that a court will go through to determine whether a state law preempts county's ability to regulate in a particular area. We're going to get a bit more into this test as we go through the presentation today. But again, wanted you to be aware of this test that's out there as it relates to preemption activities and things of that sort. Before I move on, a couple of questions. Will the recording of this be available after the meeting? I'll answer for Sarah. I believe the answer is yes. Will the PowerPoint be emailed out to those who registered? I don't know that it will be emailed out. Maybe Sarah, you can address that, but I think that it will be made available on the Counties Association website. So when we look at the authority to regulate, as it relates specifically to solar and wind energy systems, it's a limited authority to regulate. This is an area where the state legislature has preempted counties' authority to regulate renewable energy systems. It's not unlimited in terms of the preemption. In other words, the state has not said counties, you can do nothing with renewable energy systems, but they have specified certain categories of these systems where they have essentially taken counties out of the ballgame, if you will. And we'll get into that as we go here. So again, broad proposition, we have to ask the question, is there preemption as it relates to renewable energy systems? There is preemption, and that's what we're going to talk about today. So I am done talking for the moment. I'm going to turn it over to the expert in the room, that being Jake, to go through some of the finer points associated with this whole concept of preemption.
Yeah, thanks, Andy. And so I think this slide is worth noting, like Andy said previously, he's absolutely right. Sometimes we get questions relating to, well, what exactly is renewable energy, right? And there's lots of different nuances, but ultimately, like Andy previously said, we're talking specifically about solar energy systems and wind energy systems. And, you know, the legislature sometimes doesn't make it easy on us. So for solar energy, we're looking at Chapter 13, specifically for that definition. But really what we're going to be doing is operating within Chapter 66. That's really what the focus is going to be on. But again, as Andy said earlier, solar and wind, they're interchangeable in that really we're talking about renewable energy. So just generally speaking, right, when we're looking at 660401, we need to understand that there's a process and there is a role for a county, but otherwise there's preemption for county regulations unless expressly stated. And we'll get into kind of the elements that you can work through when trying to determine exactly what the county role is. But as Andy said, it's limited. And we'll get into the details here in a second. So we're going to be talking about a few cases today that we'll try not to get too far into the weeds, but it is helpful to understand really the 3 key cases, because ultimately, right, we can talk about the statutes, but the question from a practical standpoint is, you know, how do we apply them? How have courts interpreted it? You know, where exactly is the role for counties to operate within? And it's helpful to understand how the courts have actually looked at that. There's 2 of the cases that are actually relatively recent. And so I think it's helpful to know that. This is really one of the key points, that the conditions that we're going to talk about here in the statute that may be used are the standards that constrict the power of subdivisions, counties, towns, not openings for them to make policy. In my mind, that's really the key point. The way the court looked at it in this Ecker Brothers case from 2009, they're not viewing this as really broadening the scope of counties. There are some conditions and there are some elements that can be met where a county can operate within. but they're not really interpreted by the courts as this broad opening to really engage in policy making. There's steps that we need to follow, and there is some flexibility there. But we think this is a really important point to consider, because if you're ever in a situation where there's a challenge, the courts are going to look at how other courts have interpreted this, and they have not interpreted these broadly. So this is where we're really going to get into the specific restrictions on the county regulatory authority. In the second half, and hopefully we'll have time for that, we'll actually get into what the process is to actually have a permit process for renewable energy systems. But we thought it was more important to start with really where we're seeing more of the key questions. And that is, how has the county's regulatory authority actually been restricted? So again, we're looking at 660401, and in particular 1M. This is really, really important. So a county may only place a restriction, and it's broadly interpreted, either directly or in effect, on the installation or use of a solar energy system. And again, we talked about how that was defined earlier, or a wind energy system, if the restriction satisfies at least one of the following conditions. So again, the court is going to look at this if there's ever a challenge. Did the county actually look at these three conditions and actually work through the conditions? So restriction serves to preserve or protect the public health or safety. Was there an actual focus on public health if you're going to have a process in place? Second, the restriction cannot significantly increase the cost of the system. There's going to be a cost analysis done here. And then third, does a restriction allow for an alternative system of comparable cost and efficiency? So again, these are the three conditions that you need to be mindful of if there's any thought given to a local regulation. Really important point here, the counties are not permitted to make general policies applicable to all solar energy systems. You're going to kind of see a theme here as we go throughout the following slides. This needs to be a case-by-case analysis, just like you go through for a conditional use permit. We cannot have kind of a broad brush restriction on all renewable energy. It needs to be a case-by-case analysis, looking at the facts of each particular case. That's what the statutes outline, and that's the way the courts have interpreted this, right? We want to have a process where every request is viewed in a case-by-case analysis and not just a broad restriction. So again, looking to the cases, the Eckers brothers case is really the most important case on point. There, the court looked at the county must hear the specifics of a particular system and then decide whether a restriction is warranted. And we've highlighted the second point. It may not promulgate an ordinance in which it arbitrarily sets a one-size-fits-all scheme of a requirement for any system. So again, one-size-fits-all, broad brush, whatever language you want to use. We need to be looking at a fact-specific analysis for each project. And in my mind, if you get nothing else from the presentation, this is the most important point. Now, this is the only point we've highlighted in our presentation. If you have an installation or a utilization of a facility, and facility is very specifically defined under actually chapter 196 to define it greater or equal to 100 megawatt project. If you have an installation or a facility that meets that definition, for which a certificate has been issued by PSC, it is precluded or inhibited by a local ordinance. So if you have a local ordinance that precludes or inhibits, and there's some case law language that we'll get into in a second, specifically kind of broadening that point. It's not just preclusion, it's actually if you inhibit or impact a project, or in this case, a certificate in some way, then the installation and utilization of the facility, again, the defined term, can still proceed. So what does that mean? Basically, if there's a certificate that's been issued by the Public Service Commission for a project that's 100 megawatts or more, it's going to proceed whether or not there's a local ordinance in place. So, Andy, I think you would agree, this is pretty strong preemption language.
Oh, it's huge. And here's the issue is that the developers know all about this preemption as well. They know all about the threshold. So Jake, you and I were talking before about how a lot of these developers understand that if they build a 101 megawatt facility, that puts them in a much different regulatory framework than a 99 megawatt facility. So this threshold question of is the proposed facility 100 megawatts or more is huge. It's a critical question in terms of defining the scope of a county's regulatory authority.
Right. I mean, that's really kind of what's happening, that from our standpoint, what we're seeing statewide is a lot of these projects are very, comfortably above that 100 megawatt threshold, which then brings into this, again, what we call the CPCN, the Certificate of Public Convenience and Necessity. That's basically the certificate that a project developer needs to obtain from the PSC. And then, so we'll go to the next slide, because at that point, the PSC then has to have a public hearing, and there's 8 factors that they need to consider. And so you just go to the.
Yeah, I will, but I want to point this out on this slide too, because this is such a critically important point, is that the legislation says that PSC shall approve the application. There's no discretionary authority where PSC says, well, you met the 8 factors, but we really don't think that this is a good project. No, that's not there. PSC has to approve an application if the application hits the 8 factors. So the 8 factors, we'll go through those now.
Yeah, Andy, you're absolutely right in that a lot of these developers, they know what they're doing. They work through these certificate applications, numerous applications annually, and they know how to meet these 8 factors. We're just kind of highlighting, I think it's, the 5 most obvious ones. There has to be a reasonable need for supply of electric energy. The design and location, right? So they're going to look at the route. They're going to consider alternative sources, alternative locations, routes, individual hardships, engineering factors, right? These are all going to be the things that PSC is looking at. This third one, the proposed facility will not have an undue adverse impact on other environmental values. Obviously, that's pretty broad language. But this is statutory language. And so some of the things PSC is going to look at is ecological balance, public health and welfare, historic sites, geological formations. You can actually go on the PSC website. So it's actually a very nice map. It shows a map of Wisconsin, and then it'll actually highlight the pending CPCN applications before the PSC. And so when you pull those up, you can see the applications. They're hundreds, sometimes 1,000 pages. Hitting all these elements, right? So for example, as far as environmental values relating to ecological balance, public health and welfare, they'll have reports, they'll have data. And these are very well done reports. And to Andy's point, if these metrics are basically met under Chapter 196, the PSC, even they really don't have a lot of discretion here, right? If those elements are met, they shall issue a CPCN. And then obviously the final 2 are also unreasonable interference with orderly land use. That's where, right, we're going to have impact on county zoning and things like that. And that's some of the points we've heard working with the counties that we have on these projects, that there is concern, and I understand that there could be, right, they focus on this language relating to orderly land use. But again, if there's been enough adequate information provided within that application to PSC, if PSC makes a determination that element is met, as along with the other 7, they're going to issue the CPCN. So a lot of this is what we just talked about, right? So what exactly is the county role in the PSC process? They can certainly submit comments, and we've encouraged from the counties that we've been working with. There is a process, right? I mean, it's just like an administrative rulemaking process, and then there's a deadline where an entity can submit comment, can actually participate in a hearing. But ultimately, as this language indicates, the way the courts have looked at this is that, and we highlighted really the key point, if the installation or utilization of a facility, again, facility being defined as 100 megawatts or more, for if a CPCN has been issued, there's not going to be a lot of room for a local ordinance impact. In fact, if a CPCN is issued, they may nevertheless proceed, even if there's a local ordinance that may be interpreted to conflict with that certificate.
Now, that doesn't mean a county cannot submit comment to PSC.
Absolutely can, yeah.
And so a county can always do that, but understand that the county has no jurisdiction to preclude a facility that the PSC has approved. That's a very important point. So the role in the process shifts from regulator over to public commenter. And does the county have any more sway with the PSC than another member of the public? I think it kind of depends upon the circumstances. And so if a county desires to provide comment to the PSC through this process, a county would be well served by focusing on the conditions associated with PSC's approval. Because again, remember that if it's a facility where it's more than 100 megawatts, PSC has to issue that permit if all of those conditions are satisfied. And so now let me just take a brief break here to recap, if you will, because we had a couple of questions that touch on this, and I want to make sure it's clear. When we're talking about this whole concept of the case-by-case requirement, that applies to every single renewable energy project, more or less than 100 megawatts. If the project is more than 100 megawatts, jurisdiction transfers from county over to PSC to approve that project. That doesn't mean that every single land use regulation is thrown out the door. There still may be regulations that a county can impose consistent with 660401 of the statutes. Fine. Even those factors, though, to be applied, you have to consider on a case-by-case basis how those others and allowable regulations are going to be applied to a particular project. All right, so I want to make sure that's clear. We have another question. Who determines what is and is not a human health hazard as it relates to renewable energy systems? And let me just start, Jake, and then you can fill in. Under county zoning code, of course, we have to have substantial evidence supporting the imposition of some sort of regulation as it relates to typical zoning. As it relates to the PSC factors here, that's a PSC determination as to the impact on environmental values and the impact on human health and things of that nature. So that's ultimately a PSC determination. Anything you wanted to add on that or other thoughts?
No, I mean, I think that's right. And I would really emphasize Andy's point previously about what the county role actually is within the PSC process. Again, because I sometimes hear the comment, well, if we have some sort of ordinance, we can go to PSC and cite that. As Andy said, that's not really the role at that point. If we're at 100 megawatts or more, we have a CPCN application, you're in front of the PSC. We're focusing on the factors that Andy has up on the screen right now, right? So it's those 8 elements under chapter 196 that we're focusing on. It's not some other county restriction. Now, to the question, so it's a good question, right? So if there is a focus on one of these elements, an environmental hazard, does the county have a role again in the comment process? Absolutely. It can bring forward information, and frankly, in some ways, it may be in the best position to do so. But again, it's not going to be from the standpoint of additional regulatory authority. It's going to be from the standpoint of, hey, the county and its expertise has information relating to a possible health hazard. Let's get that information via comment to PSC so that they consider it when they are actually going through their analysis of those 8 elements. So that is a really critical point that Andy made, distinction between county regulation and simply submitting information to PSC, which absolutely a county can do.
So here's a good question. I think it's a great question. So what is the definition of a facility? Can you link different projects on separate parcels of land to meet the 100 megawatt threshold?
So my understanding is that yes, right. So if you look at that, I referenced the PSC website. If you look at the PSC website, they actually will have the projects broken down by county. And if you look closely, there's typically going to be a map of the county and the project area. And you know, the ones I've seen typically will have parcel A, B, C, right, that encapsulate the project. And it's going to be a certain number of acres. So it's not necessarily looking at one specific parcel. It's kind of broadly speaking the project as a whole. And then that project taken together, does it exceed that 100 megawatt threshold?
Another question here, I think it's a great question because it speaks to this concept of the county role here is what do we see in terms of development agreements? Because I mean, we've heard, and I think others have heard too, PSC places an emphasis on these developers being part of a developer agreement with a prospective county or municipality. Has PSC delayed approval absent a development agreement and so on? I will tell you that there's no legal requirement that there be a development agreement, just like there's no legal requirement that there be other agreements in place with other land use issues. But I think from If I could speak from a developer standpoint, I'm sure the developer wants certainty as to the regulatory atmosphere, if you will, of a particular project. So they're going to want a development agreement. From a county standpoint, I think we want a development agreement because we want to know that the developer is going to meet the certain requirements associated with this project as well. So have you heard anything about PSC though, giving preference or delaying permits based on the developer agreement?
So I don't have any information as to whether or not the PSC will delay issuance of a CPCN based on the lack of a joint development agreement or the ongoing negotiations of one. However, I would say I really echo Andy's point that to the extent you can push attention and push energy towards a joint development agreement, the better. Obviously, I can't disclose too much. We're working with a few specific counties, but generally speaking, instead of kind of this debate over, is there a way to get creative to put a county in a position to regulate and potentially really impact that preemption language that we've been talking about, my encouragement has been focus on a joint development agreement. In my experience, the developers that are most active in this space, that are working to try to get the CPCN certificates, have been very accommodating when it comes to meeting with counties, discussing the terms of a joint development agreement. And those joint development agreements, right, these are the kind of the legal factors for a certificate. But outside of that, these joint development agreements can address things like impact to roads, right? These are sometimes big projects. You have an impact on roads and can really cost the county in the long term. The developers are willing to, in my experience, negotiate with the county so that they can help offset those costs to improve roads. And you can get really granular here. What happens when, if there's concern that there's a fire hazard? These occasionally they've been known to catch on fire. Well, what happens? How does a town in a rural community get first responders to that? Right? There's language in these joint development agreements that can address that. There's any number of issues that these joint development agreements can address. And so my encouragement is, if you find yourself in a position where there's a possible project in your county, immediately start talking through, well, what does a joint development look like? And these aren't a secret. So typically the joint development agreement, the draft, is actually going to be included in the application. You can go right on the PSC website, pull up the project, look at the application, and there's almost always going to be a draft joint development agreement within the application that you can read through and negotiate with the developer. So I think it's a great tool. It can be negotiated. You can put the county in a really good position to actually address some of the concerns that some people are going to very rationally make when these projects come into their county.
So how does the county get notice that the PSC is considering an application?
So I believe there's a process for a formal notice to be submitted to the county. But again, typically this is going to be a project that takes time. Typically the developers are actually going to work with the county, put them on, whether it's formal or informal notice, but put them on notice that there's a project being contemplated. Now, I want to make clear that that's not, if they're going and talking to local property owners, there may not be any sort of notice given immediately. But ultimately, when the county finds out about this, there's going to be a role for them to have conversations with the developer. And like I said, ultimately, these applications are the first thing that's going to be filed with PSC, and they are robust, right? These are hundreds, if not thousands of pages. Really, any information that you think that the county is going to need is going to be in the application.
So what's the typical size in terms of acreage of a 100-megawatt facility that you've seen?
I think that can vary really widely, right? Sometimes it's going to be 10, 20 acres, hundreds of acres. I think it really depends on the size. And that gets into, and this is probably beyond our capability, but as far as, the spacing in between the panels, how close they are, right? I mean, we haven't really talked about some of the practical realities here, why certain counties may be more subject to being focused on by these developers and others, and that is flat terrain, access or proximity to transmission lines. That's huge, right? I mean, you can basically look at a map of Wisconsin, look at where the main transmission transmission lines are and determine which counties are really going to be the ones that are going to get a lot of attention by these developers. It's just the reality of kind of the geographic layout. And so, those are the factors that you need to look at. And if you're in one of those counties, then yeah, you're probably going to be getting attention.
All right, so in looking at these factors, I don't see the requirement, but have you seen any applications, formal environmental impact statements being submitted?
I know that that has been brought up in some of the counties we're working with. That's something I think PSC will consider and will look at. I don't believe it's a formal requirement under 196.
Right,
But-
that's my point. It has a lot of information that's similar to what you'd see in an EIS, but not a formal EIS requirement.
Right, I think that's right.
All right, so in here, just to clarify something we've talked about earlier, if a county has either a declaration by county resolution or a statement from administration, or for that matter, an ordinance, and says, we find these facilities to be human health hazards, that is going to have zero impact on whether the PSC approves or disapproves that facility if it's over 100 megawatts. And I shouldn't say zero impact, because of course the PSC is going to receive comments, but that's not going to carry the day. Is that right?
I think that's right. Again, I think that's why I said your point is so critical. The role for the county, once that CPCN application is submitted, is to submit a comment. And so in a situation where that the county or some of the county believe there's an adverse environmental or health impact, put together a formal comment and submit it to CPCN. Excuse me, to the PSC as part of that CPCN process. They're going to take it into consideration. I mean, we'd have to look back to see, how extensively the PSC has taken into consideration those comments. And, it may be hard to even determine that, but there absolutely is a role for the county in that situation. And so again, just like with the joint development agreement, it's how are we going to focus our energy? I think it's probably fair to say that a formal comment from a county that's the home county for one of these projects is going to get special attention from PSC. Now, does that mean that they're going to necessarily agree with the county? They may not. But I think that's a better use of time than again, as opposed to trying to get creative and trying to throw up a roadblock that, as we saw statutorily and as the courts have applied, is not going to impact how PSC ultimately makes its determination.
Well, here's a good question. What if under the county zoning code, we have property that's zoned residential or property zoned commercial? So we have approved zoning classification. Somebody wants to put a solar facility on that property. Is the fact that it would be contrary to existing zoning code, is that going to be dispositive of placing the facility on that property?
I don't think it's going to be dispositive, but I think so in that situation, I think there certainly is a role for the county to play. And frankly, again, we've worked with some counties where you're going to have a planning zoning committee. And in that situation, I think the developer probably has a responsibility to work with the county to ensure that that's a significant difference, right? Commercial versus residential. I mean, typically from a practical standpoint, they're going to be looking at, again, flat farmland. Again, just kind of a practical side of this, but I think that's something.
Open space, they need open space, they need
space.
flat open space,
Right.
typically flat open space that is near a transmission line. And to your point earlier, Jake, you can go on the PSC website and see where these proposals are being made. And you can predict with some regularity where these solar farms are going to look to be placed based upon that map. Just like we had this conversation just yesterday, just like we saw the proliferation of the large windmills through the wind tunnel, if you will, through Dodge, Fond du Lac, Kewaunee counties, you're going to see similar attributes as it relates to the placement of solar facilities based upon the characteristics of the land and their proximity to the transmission lines.
Right, but I guess just the word of caution though, and we'll hopefully have time, and if not, people will get access to the PowerPoint. And that is when you look at some of these cases, right, if it's impeding or hindering the certification process at PSC, if there's a local regulation, county zoning requirement that impedes or hinders a certificate application, some of these courts have interpreted that as essentially adding a restriction that's not consistent with Chapter 66 or 196. I mean, And we're not really even saying that's right or wrong, right? That's the reality of how the courts have landed on these issues.
So here's a good question. Okay. Number one, I want to point out that if you want to look at examples of joint development agreements, you can go to the PSC website, pull down some of those applications, and they've got the agreements that are contained right in there. As well, there are other counties that have looked at this concept of joint development agreements. If you want to call us offline, we can probably give you some information about that. But the other question I think is very interesting here posed, and that is, okay, so we have towns within our county that have ordinances, zoning or otherwise, that regulate solar facilities both under 100 megawatt and over 100 megawatt. We know as a county that the towns have no regulatory authority for the over 100 megawatt facility. What do we do about those ordinances on the books? For me, I don't think you do anything with them. It's not our job as a county to basically tell a town that you have to wipe those off the books, but we have an understanding that, you know what, that ordinance is not going to be enforceable as it relates to the over 100 megawatt facilities, unless the ordinance regulates something that the legislature has said you have the ability to regulate. What are your thoughts?
Yeah, no, I think that's exactly right. I see the questions from a good friend of ours. And I think we've talked about this, that this is not just county, right? These are local ordinances, right? So whether it's town, county, village, right, any sort of local restriction it is really at risk of essentially, as Andy said, being ignored. I mean, that's our word, but frankly, that's really where the statute lands on this. And so what exactly the role for the county is, right? I mean, there can be education, there can be just being a good partner with your towns to kind of work through the process. We're obviously happy to work with counties to help kind of educate towns, but the reality is, if there is a town ordinance that, again, is viewed by a court as hindering or restricting or otherwise preventing the advance of a project that has been submitted for PSC approval, if their certificate, maybe this is probably the best way to think of it. If a certificate is issued, and this is, I'm paraphrasing, but essentially the language, the project proceeds. So it's as if the ordinance doesn't exist.
Right.
And so I think that's probably the best way to approach it with the town is, you know, again, more of an educational role.
Well, and okay, so this is a great comment, is that just for your mind's eye, that there are 2 arrays in Wood County, 1,200 acres each in each array, and those are 150 megawatts in terms of the size of the facility. So that gives you an idea of how big it is that we're talking about here with the solar facility to get to 100 megawatts. Are we going to talk about tax assessment classification? No, we're not going to talk about that, other than to say that from an assessment standpoint, our understanding is that use of property as a solar facility is going to increase the assessed value of that property far greater than use of that property in typical ag operations. In other words, the tax benefit from a county and other taxing jurisdiction standpoint is going to be higher if that facility is put to use as a solar facility as opposed to traditional ag. I think we've seen that, right, Jake?
Yeah. That's exactly right. I mean, there's a calculation. So there's no secret there. Again, going back to the JDAs, a lot of the joint development agreements will specifically lay out and what that calculation is. So there's no secret there.
All right, and we keep getting back to some of these questions about zoning and its impact on these conditions, or excuse me, these factors that PSC is going to consider. We want to make it abundantly clear that a zoning classification may have an impact. It may have an impact as it relates to the PSC's evaluation of these factors, but the zoning classification in and of itself is not going to be a hard stop. It is not going to stop a particular project from going forward. Again, it's important for purposes of PSC's consideration, but it is not dispositive of the question as to whether that certificate is going to be issued by the PSC. All right. Do we have an example, Jake, of a facility that would unreasonably interfere with orderly land use and development so that PSC would not issue a certificate? I mean, you can give your experience, but I mean, from my viewpoint, this hasn't been around long enough to give us a roadmap as to exactly what would happen in particular circumstances. Have you seen that roadmap?
No, and I would agree with that. It hasn't been, right, we're talking about relatively new statutory framework here, and then B, the reality is, and I can't say I've gone through historically and looked at every application and determine kind of what the outcome was. But I think it's fair to say that generally speaking, when these applications are submitted, so long as the developer can meet those elements, as Andy pointed out earlier, there's no discretion here, it's a shall. And so I think for the most part, these certificates, these applications for certificates are submitted, and PSC looks at the elements and they consider them to have been met. Whether or not there's been any where an element has failed, I don't know.
So Wood County apparently has some developer agreements with 20+ concerns addressed. And so Wood County has some examples if you want to contact Wood County. Is there a model ordinance out there for solar and wind at less than 100 megawatts? I'm not aware of the model ordinance. I know that the Counties Association has not produced one. Are you aware of a model ordinance out there? City, village, town, county?
Not to put them on the spot, but I had been told that St. Croix was working through a process. I don't know if they're on this call, but that may be a starting point. And you know, that's the type of thing where maybe we work with WCA to put something out, but I'm not aware of it.
So on the PSC website, because this was such an important point, Jake, where on the PSC website can folks find these proposed facilities and applications?
You know, we can work with WCA to get the link out, but there is a homepage that for CPCN certificate applications has a map of Wisconsin. I don't have the URL off the top of my head, but we can circulate that. But there's essentially a homepage that lists all the projects, and then you can click on each individual project and see the application, see what the deadlines are for comment, when the PSC is going to be meeting to hear the case, to hear the application. So it is a really great website, a great tool. We'll definitely circulate that to everybody. I think it's just buried somewhere in PSC, but if you can find it, it's a great tool.
So this is a great question too, is that Portage County has seen the proliferation of these anticipated projects, more than 20,000 acres within the county being taken up. Can the county just simply place a hard cap on the amount of acreage devoted to solar facilities?
I mean, it's a good question. My concern would be, again, looking at that language we started with earlier, I don't see how, if there was a challenge to that sort of limit, how that would not be viewed as an overall impediment. Remember, one of the points we started with, if there's going to be any sort of permit process under Chapter 66, it has to be kind of case by case, looking at an individual project as opposed to just a blanket prohibition. So if you have a hard cap on acreage, and so, you know, whatever, I think the example was 20,000 acres. So if you come in, you're the next project, and you would put the county over at 21,000 acres. I mean, that's not a case by case analysis, right? That's just a prohibition based on acreage.
Yeah, I think that's a tough one. I would have a hard time trying to defend that as a reasonable imposition of a regulation, because if you're at 20,001, how is that different than 19,999? Right. I think that's tough. It's got to be case by case. I think we have to continue the discussion as counties as to how this relates to our zoning classifications, whether it be farmland preservation, exclusive ag, and so on, in a way that to best position whatever argument we would have in relation to these solar facilities before the PSC. Ultimately, it's going to be up to PSC as to whether they issue the certificate and whether the different factors have been met contained within their regulations. So that's a tough one. Bill Ellenbeck was nice enough to post in chat the link to the PSC page. So if you open up the chat box, you will see that Bill has posted a link to the page that Jake was just discussing at the PSC website. Jake, do you know how many PSC applications have actually been denied?
So, yeah, I hesitate a little because I have not actually looked through to see if there's been any denials. What I hear, again, just kind of working with counties, working with, you know, on behalf of the counties, communicating with some of the developers. The claim is always made that there's never been an application that's denied. Again, I'm not exactly taking that as gospel just because I haven't gone through. I've seen no source for that. But as we've kind of been saying throughout, most developers know what they're doing. And so if they're meeting those 8 elements under Chapter 196, the PSC shall issue a certificate. And so it wouldn't surprise me if somebody actually did a deep dive and looked back and didn't find a denial.
Well, here's the thing, and here's the way to think about it too, is that Jake said earlier, these applications are typically hundreds, if not thousands of pages long. If you think that that application has not been sufficiently discussed, deliberated, reviewed by peer groups outside of the developer, you're crazy. They've gone through the ringer before they ever get to PSC. And so to say that an application has never been denied, well, okay, we could possibly say that, but that doesn't mean that every single project ever conceived has gone forward. There's a big difference there. I think that the point here is that the earlier the county can get involved with a project to try to address these concerns, understanding again that counties do not have a lot of regulatory authority, but counties do have some sway as it relates to PSC. Counties do have some leverage when it comes to negotiating a development agreement and things of that nature. The earlier the county can get involved in that process, the better off the county is going to be. All right, so let's focus on trying to make sure the county's interests are preserved at the early stage of project, I guess you want to say inception, before the application is ever filed with PSC. All right, so we've got additional links composed in chat, and I think we're on slide 7 of a like 37-page presentation. We're at 1247 already, so we're going to try to work through some of these slides. Let me just say this now, is that if there is sufficient interest, we will do a part 2 of this particular presentation and dive into the remaining slides. We can put that on the agenda for another in the boardroom session. So we're happy to continue the discussion. We just can't continue it today. We have a hard stop at 1 o'clock. So, all right. So we've talked about this whole concept of regulatory authority and what's the county's role in the PSC process. Jake, maybe you want to address this briefly.
Well, so actually, Andy, maybe for the next 5 minutes, since we're getting so many questions on specific zoning, if you go to the next slide.
I'm sorry, I'm reading this where people are saying, yes, part 2 would be welcome. So I guess that's the answer. There will be a part 2 to this, which is awesome.
Well, and I guess it's, yeah, and this is not surprising. Our counties we've been working with, this is often how this conversation goes, because people are passionate about it. They have great questions. And so maybe in the next 5 minutes, and then we can maybe quickly summarize the second half and do another one of these.
It's called a teaser in the business, Jake. We're going to provide a teaser.
Yeah, that's why I'm a marketer, right? So I think these cases, again, you're going to get these. I think these cases are really helpful to read through. They're actually not long, right? But they're maybe 5 or 6 pages. So if this is an issue that you're really struggling with, read through these cases. So this first case, Numeric, it involves the City of Mequon Board of Zoning Appeals. So there you have 2 lot owners who wish to construct a wind energy system on their respective lots, and they applied for conditional use permit. Okay, so we've had this conversation about, okay, what sort of restrictions can we place? And in that case, the court looked at a few issues and said, look, this is a unique statutory framework that really is encouraging renewable energy. And that, you know, I think this is an important point. It's relating to 660301, so an older iteration of the statute. It represents a legislative restriction on the ability of local governments to regulate solar and wind energy systems. Again, I'm not expressing an opinion on whether that's right or wrong, but that is how the court addressed that, and that was back in 2001. If we go to the next slide. So this is Ecker Brothers. This is probably the most important of the 3 cases. This was a direct challenge to a county in 2009, so not all that long ago. The court really didn't accept the county's argument that the legislature actually authorized localities to make their own policy regarding alternative energy systems, right? So really clear language from the court that if you're going to have a regulation that hinders or in some other way impedes the CPCN process, it's going to essentially be preempted. And if we go to the next slide, right? So what is the actual scope of 660401? That's always the question. You know, how broadly are courts going to interpret this applicable section? And this is what we've been kind of saying all along. So this is a quote from this decision. It requires a case-by-case approach, such as a conditional use permit procedure, and does not allow political subdivisions to find legislative facts and make policy.
And that's important because earlier we had the question about just saying, hey, we find these facilities over X size to be human health hazards. You can't have a blanket prohibition. You can't have a blanket statement on a policy issue like this. that the statute and the courts have said, the statute says what the statute says, and it means what it means. You have to use a case-by-case approach. That's really important to understand.
Exactly. And then if you go to the next slide, I saw some questions. I know this is always a satisfactory response, but the reality is, the courts have said if there is a real concern, the proper outlet here is to go discuss the situation with the legislature. Again, this is a quote from the Ecker decision. This is where courts have really looked, is encouraging a dialogue with the legislature, because as it currently stands, this is pretty strong preemption.
Let me tell you, okay, so we had a question earlier. Has anybody contemplated legislation that would provide additional regulatory authority to counties, municipalities, local governments? I think there are legislators that have considered that and contemplated that. And I think that over the years, there have been drafts of legislation introduced to do that very thing. I don't know how far that's going to go. I really don't. And I'm not a prognosticator, nor am I a lobbyist. And so I leave that to the Counties Association and the awesome professionals there to prognosticate and lobby these different things. But knowing what I know about the monetary and other interests at stake, I would find it surprising if the legislature wanted to revisit this. I'm not saying it couldn't happen, but I would find it surprising if the legislature wanted to revisit the entire preemption concern. I think we're better off focusing our efforts on how do we operate within the existing regulatory authority, and understand that it's not exactly set in stone because it's a relatively new law. And so I think we have to figure out how to navigate this in the best way possible. That doesn't mean from a policy perspective that we agree with it or frankly disagree with it. It just means that we have to understand the county role, and we have to figure out how to best position our interests as a county within that regulatory framework.
I would agree with that. I think, well, I'll leave it at that, because the tough thing is you go to these, there's been significant hearings in various counties on this issue, and there's obviously a lot of passion. And I know some of the legislators have been, kind of involved with at least talking this through, but I think it's pretty clear that early on there was a determination that was made that it would be problematic to have 72 different frameworks for these developers to have to work through. But again, that's not to say that there may not be interest to further explore that. And just with the time we have remaining, I think this is the third important case. Right, so this is American Transmission. This may actually be, I think there's stronger language in the Eckert brothers decision, but as far as like how it actually plays out, American Transmission, I think, is very helpful, because frankly, this is a situation a lot of the counties, particularly if you go to the PSC website and look at the projects, this is literally what they're working through. And this was how the courts kind of analyzed that situation. So you had a Dade County taking the position that construction could not begin on a renewable energy project until ATC had obtained a shoreland erosion control permit. So this is another example where, right, we had having questions, well, are there different areas, the zoning code that we can rely on? Here you have a shoreland erosion control permit. And there, ATC said, look, we're just not going to apply for that permit because we view it, again, I've been focusing on that language, inhibiting or in any way impacting a project. So there the language was inhibit. Did this erosion control permit inhibit the project? The court's response was it did, right? And similar language that's expressly withdrawing the power of municipalities to act. That's looking at 196. And so we're kind of beating a dead horse here, but the reality is the three kind of key examples in relatively recent cases, right? When this is played out, the courts have looked at it and said, if you're going to hinder or otherwise kind of impede these projects, you're going to have to have some rationale beyond what we see in 66 and 196, because otherwise it's the CPCN process that controls.
All right, so a couple of cleanup points here for our part 2 webinar that will be coming. First, our requests that we address the less than 100 megawatt facilities, and that does get into the Ecker brothers considerations. That was less than 100 megawatts. So
I don't know if this is the teaser you're talking about, Andy, but the entire second half, or probably the last, we only got through about a third of this. We have the other 2/3 of this presentation, which actually goes through the 660403 403 process, right? So again, we've been focusing on 401, and that's that kind of broader application of essentially kind of preemption. Well, exactly. What happens if we're under that 100? There is a process. So the legislature did outline in 0403 a process where you can have a permit, notifying the adjacent, the property owner plus the adjacent property owners of a project, the impact of the project, and there can absolutely be conditions that you require to be met, and the legislature did lay that out. So that's really the entire second or 2/3 of this presentation, where we go kind of condition by condition and outline what that process would look like.
And let me just answer this last question, because I think it's a great point, is that there's a concern, got this in the Q&A, that our comments have been mostly negative as it relates to solar facilities. There are benefits to solar facilities, to landowners, local governments, human health, etc., that should also be discussed. Forgive us if it's not a negative. We take no view. We're agnostic as it relates to solar facilities, truly agnostic. But the situations we're involved with involve representation of counties that are looking for opportunities to regulate aspects of these facilities because of concerns that those counties and its landowners have about these facilities. So that's our view as it relates to this particular discussion, is what is the role of county government in the regulation of solar facilities? What can we do? What can't we do? We take no view on whether solar facilities and large-scale solar is good, bad, or indifferent. That's ultimately up to policymakers that make the big bucks. That's not us. And so keep that in mind as well, is that we are not looking for opportunity to interrupt what people would view to be a positive development in your county. So just wanted to make sure that was clear. So we are at our time. And I know, as Jake said, that we've gotten through about 1/3 of this. Sarah is going to make this PowerPoint available on the Counties Association website. So what you all can do is read the rest of the presentation, nitpick it, break it apart, point out any errors, and then attack us with it the next time we get together. We would love that. That would be awesome. Kidding aside, we would like to have an awesome discussion. The reason that I like focusing on the Q&A is that's getting to the heart of what it is that you all want to know. So forgive us if some of you are saying, oh boy, can we just move through the presentation? No, the in the boardroom format was designed to get information to you in a way that you want it and allow you to ask these questions. And so we like these questions and we love answering them. So feel free to keep asking questions even when we get together next time. And Sarah, I guess you and I will have to sit down and figure out when next time is. So with that, I'll turn it back to you, Sarah, to maybe give us a closing.
All right. Thank you so much, Andy and Jake. That was wonderful. We had a huge number of participants this month for In the Boardroom, and I will work on getting a part 2 scheduled. We are working as well on scheduling a 2-part series on public records that we were going to host outside of In the Boardroom. But I do want to make a plug for next month's In the Boardroom, which will be held on March 22nd. The topic for that will be the odds and sometimes confounding questions arising under the open meetings law. So with that, we hope to see everybody back on March 22nd, as well as hopefully you can join us as well as we continue to work on other educational opportunities for you, whether that be part 2 of solar energy, our 2-part series on public records law. So stay tuned. And again, as Andy mentioned, if you have topics that you'd like us to consider for In the Boardroom or other educational opportunities, please get a hold of me at the Wisconsin Counties Association. So again, thank you so much for joining us today, and we'll see you next month.
Thank you, everybody. Stay safe with this weather. Bye now.